Welcome to our YouTube video series on termination for employees. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we'll be dealing with employees who find themselves terminated from their jobs after the Covid-19 coronavirus pandemic, where their employers have used the pandemic as the reason for not only terminating them and firing them from their job, but more significantly, choosing to not offer them any termination pay and little to nothing in the way of severance pay. So what does this really mean? Well, there's a couple things we're going to talk about. But first of all, what these employers are really trying to do is they're taking the most aggressive stance. They're oftentimes improperly or overstating the law as it is in an effort to try to avoid making any payments to their fired employees. So one of the clauses you'll see sometimes is they'll cite a clause from an employment standards code which states, if the contract of employment is or has become impossible for the employer to perform by reason of unforeseeable or unpreventable causes beyond the control of the employer, then the employer is technically entitled to terminate without notice, without termination pay in lieu of notice, and by effect without paying severance pay. That is, in all estimations, a major stretch. It is a major perversion of the law, and it is an attempt to exploit the law in a way that the courts have yet to determine, and it is unlikely, based on legal precedent in relation to this, that the courts would take that kind of interpretation so swiftly and as such a draconian matter as against the employees. Especially when one considers that governments had previously stepped in and extended all the government assistance programs, whether it's employment insurance or other programs, to alleviate the pressures on the employer from having to carry the employees. This provided extended temporary layoff periods, and even those temporary layoff periods could have been extended even beyond the statutory periods that were provided. And the government is still picking up the tab. That hasn't stopped. But what the employers chose to do is they chose to take advantage of this, manipulate it, and approach it in a most draconian way and say, this is continuing to be not the most profitable experience for ourselves. Even though the government's picking up a tab, we want to take advantage of the opportunity and eliminate these positions. And that is what they have done. And in truth, it is going too far by the employers, and they do not have the legal basis, or at least the established legal basis, to overexert this kind of position. Nevertheless, they know from past experience that most employees will unfortunately fall for these tactics and not aggressively pursue these matters as against them. They'll be resigned to the fact that what the employer says appears to have some basis in law. The government's picking up the tab as it is, and they have to resign themselves to that situation and move forward. And that is something they should not be doing. But there's a more important aspect at play in these situations. And that is the fact that where an employer uses such draconian procedures at this point, it reflects an overall approach to their employees. such that if they are draconian right now, if they are minimalist in what they're offering their employees right now, it begs the situation as to what transpired previous to that. And in my experience looking at these situations, those employers that are taking action so aggressively against their employees so as not to offer termination pay and severance pay, these tend to, more likely than not, be the same employers that have done wrongs against their employees in the years preceding this year. And it creates incredible legal exposure, incredible financial exposure to those employers, because that is their attitude towards employees. It's not always going to be the case, but it's actually more likely than not that those are the employers that have done other transgressions with respect to the prevailing law of employment standards. So, this creates a very solid foundation, oftentimes, upon which to move against those former employers who have taken such a draconian and ruthless approach as to deny termination pay and severance pay to their employees. So if you find yourself in this predicament, do not simply shuffle it off and be resigned to the fact that your rich former employer has took a nasty swing at you, and the fact that they've utilized language which you don't fully understand possibly, but seems to suggest they might be right, because it's unlikely that they have the facts straight. The law is not truly on their side. And more importantly, if this is their approach, there is a strong likelihood that there are many more issues and skeletons sitting in their closet when it comes to employee pay matters, such that to simply overlook at this, not deal with this, is going to be something that will work to your detriment, frustrate you, and aggravate you for years to come. So at a very minimum, you should be pursuing this, looking at this, and seeing if there is a legitimate base to challenge the claims of your former employer. Because in all likelihood, there is a lot to go on, although maybe not in every case, but taking such a draconian approach, it is highly likely that there has been errors and major missteps, as the employer that you had has overstated its position and is simply trying to pressure you out and try to keep all the money for himself. Thank you.